Merry Christmas. Here we go. Good morning. Welcome to House Judiciary. The committee will come to order. Madam Clerk, please call the roll.
Chair Breen.
Present.
Representatives Edwards.
Here.
Carter. Here. Hope. Here. Arbit. Devendorf. Here. Hoskins.
Here.
Cerniglu. Here. Fink.
Here.
Wenzel. Here. Wozniak.
Here.
Outman. Here. Johnson.
Here.
He is here.
Okay,
I don't
so
know if
you're,
he said
all right.
it.
Okay. Madam Chair, you have 12 members present.
I
You
just
do
want to
have a quorum.
clarify, Rep. Outman, you are here? I'm not here. Okay, you are physically present. Your mind might be elsewhere, that's okay. I hope all is well with the new baby and your lovely wife and your other child. Okay. All right, I'm taking a motion from Representative Edwards to approve the minutes of the March 6th meeting. Thank you. Those are now adopted. Today, we are going to be voting out House Bills 5392, 5534. I see we have a less than packed room, which is a change of pace, but we do have some very important people in the audience. And one of them is Mr. Trevor Van Dyke from SCAO. I am going to ask that he come up here and talk to us about these amazing, wonderful bills that we can all get behind, I hope, maybe, and tell us about the substitutes that are happening.
Thank you, Madam Chair, for the opportunity to go through the substitutes. I think the less than packed room is probably because I am up here speaking about the substitutes, but I'll try to get through it as fast as I can. First off, I want to thank LSB for their work. I know that they did a lot of work over the last few weeks trying to get these in a position that are before you today for your consideration. So with that, I'm going to go through substitute for 5534. I'm going to label a bunch of them with a little bit more details as some technical cleanup. For example, there was some inconsistency of use of terms throughout the bill with regards to trial court fund and state trial court fund. So we condensed it just to reflect trial court fund throughout the legislation. There was also some cleanup with regards to Section 3 with regards to operation costs and funds needed. It just clarified minimum and additional. That is also elsewhere in that sentence, so it was kind of duplicative, so that just cleaned up there. We also, in Section 4, added on line 28 to after statute, we included or ordinance. So this would include recommendations for anything for statute or ordinances. The other cleanups, I think this is from a list from Treasury, cleaning up the wording for the sections that they are responsible for with regards to Section 5 and 6, and doesn't change any of the actual implementation. It just kind of clarifies what kind of the wording that's in there that was kind of duplicative in nature. The last change that I'll reflect is that I would deem as technical cleanup is just a lot of the cross references throughout the bill. Because we added a new section, it changed the section references, so we had to clean up and make sure that they were appropriately reflecting the correct cross references throughout the legislation. For some of the substantive changes, on regards with page 2, line 14, this is the maintenance of effort definition. It clarified that state and federal funds are not included in that calculation. In regards to, on page 2, section 3, it added subsection B, and this clarifies that the costs of prosecution and defense are not to be included in the local funding unit's maintenance of effort. Another change, and this was for clarification purposes, to clarify that Section 4, this is for SCAO to develop recommendations and not for implementation. So there were some changes in the wording there with regards to proposed to clarify that. I'd also like to highlight for further comfort, Section 8 on page 7. This specifically references that SCAO is to develop legislative proposals to effectuate sections 4, 5, 6, and 7 of this act. So any changes would have to come before the legislature just to put more minds at ease there. Another change was with regards to a new Section 7 on page 6. This is line 17. This would require SCAO to work with Treasury to develop proposals for court facility capital improvement cost. Another change is Section 9 on page 7. This would add the requirement the SCAO report must include the median cost of judicial benefits provided by all trial court funding units. And of course, at the end of the bill, this is now tie-barred with 5392. In regards to House Bill 5392, there was a modification with regards to the sunset date. It moved it from May 1st, 2026 to December 31st, 2026. The request was from SCAO for this, mainly because our collection of data that's outlined in the previous bill probably won't be fully complete right by the May 1st deadline of that sunset. We think that will be completed and turned in, but we also want some time for the legislature to read, review, and decide if they want to move forward with any of those legislative proposals without the May 1st sunset and getting that report at the same time. So that was the line of thinking with that sunset. And of course, the end of that bill is also now tie-barred with the 5534. And I think that is a high-level overview of the changes that are in the substitutes that are before you for consideration.
Thank you, Mr. Van Dyke. Just to add some clarifications, I spoke with the Executive Office of the Governor regarding the proposed sunset dates, and it appears all entities are on board with those itemized sunset dates. Is that your understanding?
Yes, that is my understanding as well.
Okay. And I also understand that some of my colleagues, including Representative Lightner, they had submitted some requested changes. Are there any requested changes from any members of the legislature that remain outstanding, or have they all been incorporated?
They have all been incorporated in these substitutes.
So anything that has been requested by any one of my colleagues has been put into these substitutes, and there's no other outstanding issues?
Yes.
Okay. And just to clarify, because I know this is a very complicated process which SCAO is undertaking. However, these bills in and of themselves do not outline any new revenue stream for the trial courts. It is simply a data collection plan. That's fair?
Yes. I think
So until the reports and information are submitted by SCAO, everything remains as is.
that is correct.
Okay. Just making sure that there are no other outstanding issues here. Okay. I understand Representative Wozniak has a question.
Thank you, Madam Chair. Good to hear your voice.
Coming back.
Mr. Van Dyke, I know you're not a fortune teller, but how do you see some of this? I know it's only data collection now, but how do you see the difference between a court that loses $2 or $3 million a year versus courts that sustain their own balance because they pay attention?
Yeah, I will not pretend to be a fortune teller, but that is one of the issues that will have to be tackled in these recommendations when we get all this data to figure out how future trial court funding should be appropriately handled. And that's going to be one of the issues that needs to be addressed. And I think that's why the bill calls for us to collect a lot of this information to help inform the legislature on a path forward with that.
Yeah, and what the concerns that judges have approached me with is that they're going to be penalized for doing a good job and their funding taken to another court that's not doing a good job. So that's part of my fortune telling. Thank you.
Representative Fink.
Thank you. Look, while I appreciate, and I certainly appreciate the work that's going into this legislation, and I appreciate that the bill we're looking at here, 5534, does not in and of itself establish any particular funding requirements or limitations or what have you, but instead direct SCAO with the maybe not mandatory, but seemingly compulsory caveat that it's under the direction and supervision of the Supreme Court anyway. That it directs SCAO to conduct these studies, analysis, data collection efforts, whatever you want to call it. you know, my belief is that what will happen, I guess if we're talking about fortune telling, my belief is that what's going to happen here is that SCAO is going to come back with recommendations, and there's going to be enormous pressure on the legislature to adopt those recommendations. In other words, I think that we're probably at the fork in the road today, that in a technical sense, we might actually be at it in a couple of years when the recommendations come back, but I don't think it's that realistic that the legislature is going to resist that directly. And so one of the things that I kind of wanted to get at here is there something compelling? Because the way that this is broken down, or what is suggested here, is that the marginal cost of a case is the only amount that is appropriate to assess on a defendant for court costs. One of the questions I have about this is are we compelled to adopt that? In other words, is there something constitutional, something external compelling us to adopt that approach to limiting court costs to only the marginal costs on the defendant?
I do not have that information in front of me, so I don't want to give you the wrong answer. But I know that, again, in my read of this is one of those things that was highlighted. I think it really coincides nicely with the commission report and the recommendations, and that's why we viewed this as the necessary next steps to gather appropriate information and data to bring forth to the legislature for that larger problem. And that was identified as one of those issues that should be brought forward with when we collect that information to make our recommendations.
Okay, thank you.
Mr. Van Dyke, it's to my understanding that we have recommendations from 2019 as outlined in the report, the Trial Court Funding Commission, correct?
Correct.
And those recommendations, however, have to be supported by data, correct?
Correct.
And that's what this bill is doing, is gathering that data so that we can then, later on down the road, the legislature can then act on those recommendations with the data in hand and give further direction to SCAO. Is that correct?
That is correct.
Okay. Am I missing anything?
No.
Okay. So the final authority for how courts will be funded is still vested with the legislature after we gather all of the appropriate information.
That's correct. That's what Section 8 specifically puts the ball in the legislature's court, where the recommendations for implementing any of those sections come back to the legislature for implementation.
Okay. So it's not like SCAO is going to be able to take over any other court and tell them what to do.
That is correct.
That's our job.
Yeah.
Okay. Representative Fink, you have a follow-up?
I do. So we have these recommendations from 2019, and now there are people, you, others, sitting at the legislature telling us that we need to move forward with those recommendations, and then you're going to gather some data, and then come back and make additional recommendations as to what we should do then, right?
That's correct.
And so it seems like we are on the path that I'm talking about of other people. Essentially, we're doing delegation without admitting it, of asking other people for information and then asking another set of people or a more, I guess, more specific recommendations. And then that will come back to us, and then we'll have a decision to make as a legislature. Is that the path that we're on?
Well, I can speak to what's in the bill and what's requiring SCAO and the report and recommendations that are outlined in the bill for that. I would say that when those recommendations, again, I'm not a fortune teller, but I would assume that there'll also be other concepts at that point for the legislature to consider as well. I don't think that this would be the only proposals that would be before the legislature.
Okay, thank you.
We've been kicking the can down the road for about 10 years, right?
Yes,
With no accountability measures for anyone.
that's correct.
This is finally adding some accountability so that we can get this done in accordance with the Supreme Court decisions.
Correct.
Okay. Anybody else have any questions? Okay. I'm taking a motion from Representative Carter to adopt the H1 sub for 5392. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Post. Yes. Arvid.
Yes.
Devenport.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman. Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you. We have an amendment offered by Representative Fink for 5392. Representative Fink, would you like to speak to your amendment?
I would. Thank you, Madam Chair. This amendment would essentially break the tie bar between these two bills. As I think we discussed a little bit last week, Rep. Lightner's bill is not controversial. Without it, there's not really a way for our trial courts to be funded, and so I expect there to be at least something close to unanimous support in the legislature for that bill. But in my view, House Bill 5534, is that it? Raises different questions, including those along the lines that I brought up today of essentially delegating the decision-making here to somebody else and then having to overcome the momentum that will create there, rather than engaging in something like a legislatively led process where we could involve SCAO but do the work ourselves. And so I would like to break the tie bar so that we can move Rep. Lightner's bill without there being any danger of the tie bar holding that bill up, or the converse, which is being sort of pressured to move a bill that, in my view, is not ready because we do need to move Rep. Lightner's bill. I move my amendment.
Okay, and just to clarify, you're opposed then to the data collection from SCAO.
I'm opposed to setting us up on a path to adopt recommendations from someone else after just turning the issue over to them for 2 years. And I'm opposed to holding the trial court funding bill, Rep. Lightner's bill, hostage in order to do a more complex policy bill that, as I said, I think needs more work, and the leadership of it should not be in SCAO but should be in the legislature. We're the branch of government that controls the purse strings, and so we should take the lead on this project.
Okay, well, we have, I'm assuming you'd like to make a motion to adopt the amendment to the H1 sub?
Yes, I think I said I move my amendment.
Okay, Madam Clerk, please call the vote.
Chair Breen.
No.
Representatives Edwards.
No.
Carter.
No.
Hope. No. Arbit.
No.
Devendorf.
No.
Hoskins.
No.
Cerniglu.
No.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 5 yeas, 8 nays, and 0 pass. The amendment did not prevail.
Okay, I will now take a motion from Representative Hope to report House Bill 5392 as substitute H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 5392 is reported with recommendation as substitute H1.
Thank you. We have an H1 sub for House Bill 5534. I have a motion from Representative Arbit to adopt the H1 sub for House Bill 5534. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yep.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you. I have a motion from Representative Cerniglu to report House Bill 5534 as substitute H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Passed.
Wozniak.
Pass.
Outman.
Pass.
Johnson.
Passed.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. House Bill 5534 is reported with recommendation as substitute H1.
Also, I went out of order, and my sincere apologies. We do have some cards to read in. Samantha Gibson, on behalf of the Michigan Association of Counties, supporting both bills, not wishing to speak. Judy Allen, on behalf of the Michigan Township Association, also supporting both bills, not wishing to speak. Harrisana Richards from the Michigan Municipal League, supporting the bills, not wishing to speak. And Trevor Van Dyke, who we did hear from SCAO, supporting the bills, not wishing to speak. I see no other questions. We have nobody else that is asked to testify today. And Everybody is here. So, seeing no additional business before the committee, we stand adjourned.